I'm reading California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparable Analysis. This is a 2007 to 2008 edition, and I have produced by LexisNexis. I believe we ended up in venue within Chapter 4, titled The Proper Court. This is Subpart 3. The California Code of Civil Procedure, Section 395, discusses venue as county in which defendants reside, personal injury, family law matters, contract to perform obligation in county, contract involving goods for personal or family use. A. Except as otherwise provided by law and subject to the power of the court to transfer actions or proceedings as provided in this title, the Superior Court in the county where the defendants or some of them reside at the commencement of the action is the proper court for the trial of the action. If the action is for injury to person or personal property or for death from wrongful act or negligence, the Superior Court in either the county where the injury occurs or the injury causing death occurs, or the county where the defendants or some of them reside at the commencement of the action, is proper for the trial of the action. Subject to subdivision B, if a defendant has contracted to perform an obligation on a particular county, the Superior Court in the county where the obligation is to be performed, where the contract in fact was entered into, or where the defendant or any defendant resides at the commencement of the action, is the proper court for the trial of the action founded on that obligation, and the county where the obligation is incurred is the county where it is to be performed unless the special contract in writing to the contrary. There is a special contract. If none of the defendants reside in the state, or if the resident in the state, or if they reside in the state and the county where they reside is unknown to the plaintiff, the action may be tried in the Superior Court in any county that the plaintiff may designate in his or her complaint, and if the defendant is about to depart from the state, the action may be tried in the Superior Court in any county where either of the parties reside or service is made. If any person is improperly joined as a defendant or has been made a defendant solely for the purpose of having the action tried in the Superior Court in the county where he or she resides, his or her residence shall not be considered in determining the proper place for the trial of the action. B. Subpart B. Subject to the power of the court to transfer actions or proceedings as provided in this title in an action arising from an offer or provision of goods, services, loans, or extensions of credit intended primarily for personal, family, or household use other than the obligation described in Section 1812.1 or Section 2984.4, and that has to do with, I think, I looked into this. I believe one has to do with vehicle leasing, and the other has to do with personal injury, or one has to do with punitives, and one has to do with personal injury. So, or an action arising from a transaction consummated as a proximate result of either an unsolicited telephone call made by a seller engaged in the business of consummating transactions of that kind, or a telephone call or electronic transmission made by the buyer or lessee in response to a solicitation by the seller, the Superior Court in the county where the buyer or lessee in fact signed the contract, where the buyer or lessee resided at the time of the contract was entered into, or where the buyer or lessee resides at the commencement of the action, is the proper court for the trial of the action. And subpart C, in provision of the obligation described in subpart B, waiving that subdivision is void and unenforceable. Notes and questions regarding venue. 1. General venue rules and exceptions. Various statutory provisions govern the determination of proper venue in California. These provisions often overlap in a conflicting manner, but may be reduced to one fundamental premise as stated in CCP 395. A defendant is entitled to have an action tried in the county of his residence unless the action falls within some statutory exception to the general venue rule. When there are multiple defendants, venue is generally proper in any county where at least one of them resides In none of the defendants resides in California. Venue is generally proper in any county in which the plaintiff may designate in her complaint. There are a number of statutory exceptions to the general rules. These exceptions, in turn, may be subject to more specific exceptions. Some of the most common exceptions are discussed below. So, actions involving real property, personal injury, dissolution of a marriage, actions against corporations and associations, contract actions, residence, mixed actions. Okay. Wait, I skipped a page. Did I skip a page? No, I didn't. Okay. So that for the most part are the statutory exceptions. So first, actions involving real property. A, the county in which real property or some part of the property is located is the proper venue for most actions of recovery of the property or some interest in the property. See CCP 392. The courts traditionally refer to such actions involving real property as local actions and to all other actions as transitory actions. And this comes from Picer v. Mettler, 50 California, blah blah, 1958, and Massey v. Superior Court in 1981. And Massey is M-A-S-S-A-E. B is personal injury actions. In an action for injury to the person or personal property or for wrongful death, the proper venue is either the county where the injury occurred or the county in which the defendants or some of them reside. The courts have defined injury to person narrowly to include physical or bodily injury, but not injuries of character, reputation, mental, or emotional distress. From the Cachigudi v. Superior Court case of 1990, which involved abuse of process action, not one for injury to person. Abuse of process, right? Like, yeah, when the state sits on someone for 5 years in a legal action with no merit. Caruth for Superior Court is another source of this exception. Damage action for malicious prosecution again. Okay. You know what? These are good cases to highlight in the highlighter. So, reason I bring this up is we've got these special statutes. I forgot that one of them I think involved like consumer goods or lease goods, right? 18.12.10, and the other one 29.84.4. One might do with family or whatever. But these two cases here, which is about malicious prosecution and abuse of process on this page, I'm going to probably look at another time. Let's mark it. Why did the courts narrowly construe injury to person in this manner? What venue provision governs in such actions, if not this one? And C, dissolution of marriage is another statutory exception to general venue. And that's in a dissolution of marriage proceeding, the proper venue of the county in which the petitioner has been resident for 3 months. Next proceeding, the commencement of proceedings. And D, actions against corporations and associations. In an action against a corporation or association, the plaintiff has several venue options: the county where the contract is made or is to be performed, or where the obligation or liability arises, or where breach occurs, or of the corporation's principal place of business. Although 395.5 appears to only address contract actions, the courts construe it to govern tort actions as well. From Mission Imports Inc. versus Superior Court in 1982, and Black Diamond Asphalt versus Superior Court in 2003, which held that Section 394 is also applicable to statutory liability cases. The purpose of 395.5 is to permit a wider choice of venue in suits against a corporation than is permitted in suits against an individual defendant. They're questioning why. So, I'm just feeling super validated that when I did a venue question in one of my cases that I was looking at the right statutes. Alright, E, contract actions. I feel like I've read this to nauseam about how this is a statutory exception. You know, where the obligation arose, where it was to be performed, where the defendant arises. But sales of goods and services where the buyer or lessee resided at the time of the contract or at the time of commencement of the action. Oh, that's a good one. That would have helped me in my case. Well, I had enough in my case. Didn't matter. Residence defined pursuant. So this is 2. This is the second note. Yes. This is the second note in the venue section, which is on an unrelated topic. Residence, defining residence. Pursuant to Government Code Section 244A, the residence of an individual is defined as one place where a person remains and to which he or she returns in seasons of repose. The residence of a corporation is its principal place of business. What factors, and that's coming from 395.2 of the CCP. And then what factors determine a corporation's principal place of business? You can look at Roses versus Superior Court. For purposes of venue, corporation deemed bound by its designation of a principal place of business in corporate documents filed with the Secretary of State. So, one of my qualms with California law is like, how in the world would one, looking at the venue section, know that the definition of residence comes from the government code? How would one know that that's the ruling law? I mean, maybe that section cites to it, but from my last read of it, it did not. And that was actually the code. So, note number 3, mixed action rules. General statutory venue rules and exception often overlap and conflict when a lawsuit involves multiple parties or causes of action. Such mixed actions may occur when plaintiffs permissibly join transitory and local actions or multiple transitory actions governed by conflicting venue statutes, and when one case of action is brought but different forms of relief, some local and others transitory, are sought. Because the venue statutes do not provide any general approach to resolving these conflicts, the courts have developed their own general rules, as you might expect with venue analysis, although, however, these general court-made rules may be subject to exceptions in specific cases. See generally Arvo Van Alstyne, Venue of Mixed Actions in California from 1956. A, within this mixed action section, is the main relief rule. When a complaint alleges a single cause of action but seeks both local and transitory relief, the court will ascertain the primary object or main relief sought in an action to establish proper venue. Again, this comes from a say. Messy. When it gets messy. Honestly, I'd like to know about so this case coming up, or at least that members of the Bay Club want to bring an action on, like, you know, in federal court, state rights, like, they got like 7 different types of causes of action. They honestly are in multiple fora. So what does this venue part say about, like, part federal, part state, part local, part transitory relief, all in one? I mean, there's the main relief rule, but what if it's pretty proportionately divided among all the different causes? In actions, so in this Massey case, this involved, this was 1981, it involved an action by trusters under deed of trust seeking declaratory relief, reformation, and damages. Court determined main relief to be for reformation, and therefore the local and governed by section CCP 392 for venue purposes. Hazer v. Metler is a 1958 case, which was an action by a lessor for breach of farm lease, seeking return of improvements and damages for loss of use and waste. The court determined that main relief sought was transitory for venue purposes. Now, Part B under this mixed action rule is venue follows the transitory cause of action. When a complaint joins local and transitory causes of action against a defendant, the courts usually disregard the local causes of action to establish proper venue. From Pizer v. Metler again, Smith v. Smith, Turlock Theater. Okay, Smith v. Smith was heard in 1891. Turlock Theater Co. v. Laws is a 1939 case. So why do the courts adopt this approach? I'm just going to say, I think that the local action to me just seems like it's more complex, and you want the court, like, with more experience in a wide range of different things to hear it, because they can also disposition transitory, like, less complex issues, I think. But again, I hate don't answer these questions. These are just, what's it called, the kind of questions that you don't have to answer. Rhetoric questions. Mixed action rules. This is C under the mixed action rules. Multiple causes and single defendant, where there are multiple transitory causes of action subject to conflicting venue provisions. Generally, the court must grant a change of venue on the entire complaint whenever the defendant is entitled to a change of venue on any one cause of action. See Brown v. Superior Court in 1984 and cases cited therein. However, this judicial approach is subject to exceptions. Although the mixed action venue rule recognizes a preference for trial in county of defendant's residence, the preference is outweighed by the strong countervailing policy expressed in the special venue provision of the California Fair Employment and Housing Act, which favors a plaintiff's choice of venue. Right, because we bend over backwards to allow these plaintiffs to bring actions that they probably haven't got any right to bring in the first place. Anyhow, returning to the abusive process and what kind of misconduct? Malicious prosecution. Mixed action rules, multiple defendants, and causes of action. In cases involving multiple defendants and causes of action, when venue is proper in the county in which one of the defendants resides as to one cause of action, venue is proper in that county as to all properly joined causes of actions and defendants. Monogram Co. v. Kingsley of 1951, Tudor, Saliba, Perini, Joint Venture v. Superior Court of 1991. Plaintiff's venue selection may not be defeated if all the defendants concur in a motion to change venue to a county in which another defendant resides. That comes from the Tudor case. This approach applies even if some of the causes of action name only non-residents of the county selected by plaintiffs, so long as resident defendant is named in others. This approach becomes more complicated when the action includes individual and corporate defendants. From Brown v. Superior Court in Mosby v. Superior Court of 1974, which involved a plaintiff bringing an action against several defendants, both individual and corporate, in a county which is neither the residence nor principal place of business of any defendant. An individual defendant may change venue to the county of the residence, even though venue initially laid may otherwise be proper in one of the alternative grounds provided in 395.5. So last section before service of process, is my T's going off. 4. Motion to transfer. A defendant who wishes to contest the plaintiff's choice of venue is not the proper county must, quote, at the time he or she answers, demurs or moves to strike, or at his or her option without answering, demurring, or moving to strike, and within the time otherwise allowed to respond to the complaint, move to transfer the action to the proper court, CCP section 396B. Otherwise, the defendant's objection to improper venue is waived, and the action may be tried in the court where it commenced. They made their first appearance. Ending on page 95.